University. And 1.5 hour, we will have session, open session, questions. Probably you all can ask questions on what area that you are looking forward for exam purpose, or what area that you feel that you got some doubt to ask and all that. You can ask anything to our senior lecturer. So hopefully you all can get benefit like our law with Trump. Maybe this is one of the first, I would say, program, or I would say what we call as like forum being conducted for Bachelor of Juris, especially only cater for Bachelor of Juris. Bermaksud bahawa kita memberikan kepentingan kepada pelajar-pelajar kita yang belajar di Universiti Malaya, terutamanya kepada Bachelor of Juris. So, is that interesting? Is that interesting for us? Like we all know, right? International law, basically, before we going to start this program, basically we know that according to our Article 4, okay, Article 4 Federal Court of Malaysia, Federal Constitution of Malaysia, it stated that the highest law of this land will be Federal Constitution, right? True or not? So, according to that, which means we have to follow exactly all the rules, right? That rule must be consistent. At the same time, we need also adhere, respect the entire policy, law which govern us internationally. We need to look into that perspective also, whereby now we understood in this world that many countries not respecting the state law, international law, public international law. So what are the rules? What are the importance of the international law? Basically, that will be our topic today. The fundamental rights of our rights as a citizen of the world. Do we need to be protected under the one roof of United Nations? That's what we're going to look into. So let me ask Mr. Hakim whether he's ready. And before we bring him in, let me intro of Mr. Hakim, M.A. Hakim, Senior Lecturer of Public International Law, Attorney at Law, Supreme Court of Sri Lanka, and he also director for many organizations. This one will be director for Center for the Human Rights, University Colombo. So basically, he also a director for the department or the Center for the Human Rights, and member of the Ocean Community of Sri Lanka. A man who always been looked very high when he was also studied at University Malaya. He did master in University Malaya. He also my senior basically. So that's why we bring people in. We basically understood the policy, and also they know basic law of Malaysia, what the policy of Malaysia and all that. So he knows exactly what Malaysia all about. So let's welcome him. Let us team dengan bahasa Melayu sebagai bahasa rasmi negara kita, juga berikan saya memberi satu introduksi berkaitan dengan perkembangan pada hari ini lah, berkaitan dengan pendekatan Malaysia terhadap kepentingan undang-undang antarabangsa dan bagaimana kita melihat undang-undang antarabangsa itu memainkan peranan penting dalam dunia ini, memastikan keselamatan kita dan hak kita sebagai penduduk dunia. So let me Mr. Hakim, you are now in mute. Can you unmute and come in? Sekejap. That he's still in that line, but basically he's waiting for the correct time.
Good evening, Mr. Ram. Can you hear me now? Am I audible?
Clear and loud, Mr. Kim. So I
Yeah,
just make an intro about yourself just now.
right. Thank you. Thank you.
Uh, and basically, I'm giving everything for you now. Like let's hear what you're going to say to us on the topic all about. Thank you.
Okay. Thank you. Thank you, Mr. Ram, my learned friend. Thank you, all the participants in this brief session. So, thank you for your kind introduction about me. And I'm not an alien to Malaysian culture, Malaysian situation, because I'm a very good friend of Malaysians. And today we are hoping to discuss about the role of international law in times of crisis, how the international law should address crisis, what we call it international crisis. So that's a topic. Anyway, we can discuss in two forms. Number one, we can talk about academically what we our focus should be for the purpose of exam. The second focus may be on practical aspect of international law. When we talk about international law, there's a specific role is expected, though it's more an academic topic, but there's a significant role is expected from this international law. So anyhow, when we talk about international law, we can have a brief introduction theoretically. Then I would go into the what do you call salient features of international law. Then I would like to explain a bit more about what are the aspects of international law. Then the role of international law in times of crisis and the role of United Nations. Then we can talk about generally what do we test for the exams, because that should be very much beneficial for you also for the purpose of exam. Then finally we'll have a brief session in times of crisis, whether the role of international law is did its job, or it failed to address the problems. These are the specific areas we can talk today. First of all, let me talk about the main branches of law. When we call law, we have a very brief definition. We call there are hundreds of definitions you can call, because of the philosophers, scholars, jurisprudence. They have given different definitions. But for the purpose of our discussion today, we are having a definition for law, what we call a set of rules which regulates the relationship among, or a set of rules which regulate the society. So when we talk about a society, human society, different people, diverse people, they have a purpose of life. They live from the birth to death in a society. The society should do justice to them because they are natural being. They have natural attributes. So therefore, they should be given a free life to live as long as they live in this world. So therefore, human beings, they have natural attributes, what we call freedom of thinking, freedom of conscience, freedom of movement, freedom of speech, and so on. And because of they have born in one country, they are entitled for a number of rights, what we call their entitlements, which are guaranteed by the constitution of that country, and which are given and enforced and ensured by those governments of those countries. So this is what we call a person where he or she is living, they enjoy those rights, right? Fine. So when we talk about these rights are protected by a set of rules. What do you mean set of rules? Because in the society we know that diverse people are there, because brave people are there, feeble and weak people are there, and there are some people who have more powers, political powers, and also there are wealthy people and poor people are there. Because in order to maintain the social justice, social equality and all, we have to maintain a set of rules, a tool to govern the society. For that purpose, what we use a common measure, or what we call that common tool, it is what we call law. So this law, the origin of this law, generally what we call, earlier it was known as the fountain of law is the king or queen or the monarchy. But now, once we have learned about democracy and also sovereignty and other aspects, we know that now it is not the king, queen, or monarchy. Now we have a system what we call people's the sovereignty is given to people, no more with the monarchy or a king or a queen. So when the sovereignty is with the people, they have to people enjoy and exercise their democratic powers through this sovereignty. When they exercise their sovereignty, they will enjoy their fundamental rights. So, Mr. Ram, I need a 2 minutes break. Mr. Ram, can I? Thank you. Just hold on. I need a 2 minute break.
Can mute yourself, sir, and
Okay, fine.
break. Is it okay? Can come back. We need a break in some technicality issues. So let's give him a break. What you all could understand from this, definitely he was talking on the issue of constitution. He was saying on that set of rules, tools, and to say that the measurement need to be addressed here. What we have the set measurement is actually, I find myself when we say it about people, like we got few classes of people like politicians, poor people, rich people. But in another sense, according to our constitution, according to Article 8, equality, right? True or not? So do the law have to be functioned as equal for everyone, or the law has to be, look into people's status? We got the point, right? So he's trying to look into it, and at the same time he was explaining on the fountain of law. That's a very good word, fountain of law. Something that we need to address here. Take note on it. Fountain of law. Fountain of law here could be also meant, how does the law derive? I think if you all learn jurisprudence, we had the knowledge of Aristotle. We have all the knowledges related to Socrates, Aristotle, Plato. All these people have something to say about law, isn't it? But when they talk about law, what they used as it is, we can say what? What we can say? What we can say that they use as what actually? They use as a measurement, in a context of measurement. How they said basically was how they approached the law basically through the ideas of questions. Through the ideas of questions. That's why Socrates always asked questions. You ask anything. Even he have questioned his king on the time, basically, Solomon and all that. So we could understand that the fountain of law, what stated by our great Mr. Hakim here, but also related to Grotius, Hugo Grotius. There are few people that we need to look into according to the jurisprudence, because these people are those who actually have invented so-called the social contract. So social contract, it is not derived at the point of context, Malaysian context alone. Social contract here means something already been done, implemented many centuries ago, many years ago. I think you all know, right? Basically, social contract here means the government was been appointed to take care of the human beings. So is it that what is going on now according to the international law per se? As a whole, do we looking at the point that the international law is really governing us and protecting us, giving us what exactly they say according to the function of role of United Nations to safeguard or to make the world peace? We will come back. So I will just say a few words in Bahasa also. Di mana dalam dunia ini persoalannya lebih kepada isu berkaitan dengan society. Society. Adakah society ini betul-betul dilindungi? Kerana kita selalu berbincang dalam kelas kita berkaitan dengan isu di antara Israel dan Palestin. Saya rasa Sri ada, Miss Kate ada, kita ada ramai orang di sini, I think everyone have discussed earlier dalam kelas kita international law berkaitan dengan Israel dan Palestin ni, dan kita punya perspektif ialah apa yang dilakukan oleh Israel itu adalah sesuatu yang tidak mematuhi undang-undang antarabangsa mengikut kepada artikel 24 UN Charter. Ini telah pun dilihat dan juga dia menjadi polisi di dalam isu-isu berkaitan dengan undang-undang antarabangsa Malaysia, kerana kita mengikut kepada polisi yang sememangnya Malaysia mengikut atas dasar kemanusiaan. So when he is saying all these, apabila Mr. Hakim pointing out all these, he said society, natural being, constitution, set of rules, measure, and he said law can be as a tools, and he said fountain of law, and lastly he put the word, very important word, I think he will start with that, sovereignty. Sovereignty di sini berarti apa? What is the meaning of sovereignty? Kedaulatan. He's talking on the issue of kedaulatan. Okey, bagaimana nak kaitkan perkara ini kepada perbincangan soalan ataupun international law berkaitan dengan tahun ketiga kita? He will address on the sources of law. I'm sure that Mr. Hakim will address on the social or on sources of law, whether the related issue to the sources of law, something like, I think many of us should know that sources of international law is actually a lot. There are so many. We can call as Article 38 sub 1 SICJ. We also can have UN Charter. The SICJ here means Statement of International Court of Justice. SICJ. Those days when I was studying at University Malaya, those days, and also when I was doing environmental international law at my master, I always careful on this statute of international law. SICJ, UN Charter. I'm very careful on that because SICJ and UN Charter is like similar. It's like a lookalike. So if I use UN Charter by saying that Article 38 UN Charter, am I going to get the marks or not? Am I going to get the marks if I say Article 38.1 UN Charter? Am I going to get the mark? Definitely they will say no. Why? Because Article 38, Article 38.1 SICJ. So I also would like to ask Mr. Hakim later on the point of whether we had, because my point of view, we don't have any hierarchy on the said sources. I think I have discussed with Miss Emmy. Maybe I could share this in our team, whereby the question was very true by Miss Emmy, where she looked into a book and referring to it by saying that there are issues related to hierarchy. The words are there. Hierarchy of international law is basically we have customary, basically we have treaty, we have other sources of law. So how would I can say that they're supposed to not to have hierarchy? I was looking at the priority. Priority here means what? Apa maksud priority? Kepentingan. So the word priority here means giving importance to certain set of rules or giving importance to the set of governance of international law, which will be or maybe according to the fact of the cases, maybe or could be according to the PCIJ, whereby they could use what? Sources of customary or treaty. So maybe our great lecturer, our senior lecturer, Mr. Hakim, he will be addressing on this also. Maybe he's hearing what I'm saying here. And he could be addressing on the issue whether we got hierarchy on the said sources of law or it is actually how we look into priority. Is it the word is actually meant to be understood in that way or whether we could sense it in different way. So how does it work basically? Maybe that could be one of the questions that I am already prepared here. So dalam bahasa Melayu kita kena faham bahawa penggunaan undang-undang antarabangsa berlainan kerana mereka menggunakan statute. Dia guna statute. Dia guna apa? Statute of International Law. Statute of International Court of Justice. Lepas tu mereka gunakan UN Charter. Okay, so Statute of International Law ataupun ini dia okay. Now we bring in Mr. Hakim here. Okay, Mr. Hakim is already here. Hi, Mr. Hakim. Can you hear me? Mr. Hakim? He just requested. Mr. Hakim, I think you already up here. Maybe you can unmute. I can see. Okay, so this is what I'm going to ask to him, and probably he's going to answer us on the issue related to the sources. And also he will look into how that we're going to look into the sources and also relate that to the rules of the international law. Okay. Wait, Mr. Hakim, are you here? Mr. Hakim is here. He's already here. If you unmute, we can hear you, sir. We give a bit of time for him to come in. Maybe he got some technical issue. Let me ask him. He's here. Mr. Hakim, I think you should unmute first. We can't hear you. Some line issues.
Can't hear, sir. The sound. Hello. You have to unmute, Mr. Ram.
Yeah, I also have to unmute.
Sorry, guys, for this.
We should thank
technical
you for your time, sir. That's not.
sorry,
okay.
because I thought I can work on my laptop. Laptop is not responding to my this network.
Okay.
So you will have to excuse me to come in through this mobile phone. Okay, fine. So I apologize for this intervention and interruption during my talk on this. But anyway, Mr. Ram, you have nicely, beautifully compensated the time, and you put the discussion onto the right track. So thank you so much for that. I'm also, my job has been more eased now. So my job is going to be very easy to focus on from where you stopped. right?
Be very
So I
comfortable, sir. Okay, sir. Take
thank
over,
thank
sir.
you
Thank
thank
you.
you thank you. So I think usually when I talk to people, I have to keep on the track. So you will have to understand. First, I started with what is the meaning of law, what's the definition of law. When we talk about the meaning of law or definition of law, we used to call a set of rules by which a society is governed, right? Why you should govern a society? In order to maintain social justice, social protection, social equality. Well, that's a purpose. For that purpose, we need a tool is the one what we call law. Generally is coming from the fountain of law. Is we know that the who is the leader of the society, or the king of the society, or queen of the society, now we call monarchy. So then later stage, when after these revolutions took place, the concept completely changed towards democracy. The sovereignty of the king shifted to sovereignty of the people. Now people have sovereignty. Then only we used to call of what you call social contract theory is coming into place. I know, because the long history I have to cut short, because my Mr. Ram has given me only 45 minutes and a half, 1 hour to talk. So therefore I try my level best to shorten my discussion. uh, so then the social contract theory started. People started to elect their representatives, and then democratic concepts started. Then we know that direct democracy, representative democracy concepts started. Now later we know that state concept of state started, nation state. Then when we call nation states a group of people, unique people who have similar religion, similar culture, they wanted to have their own leaders to govern them. Then subsequently they got to know about representative democracy. They wanted to elect democratically their leaders started to do the governing. Governing means governance has three main aspects. Basically what we call making law, implementation of law, and adjudication of law. So law making, law enforcement, and adjudication. So these are the main state power and machineries. Within the state, if we say there is a government, the government should be in a position to make law in order to govern the subjects, of within the country. That means people, incidents or events, and properties or assets. The country's law will be applicable. So that is how we understand national law. So then we got to know that definition of law, the law how it became a tool of regulating the society, why the society should be regulated. Later now we see as a governance and government. So the government means we should be a sovereign government. Sovereign government should be in a position to control people, and whatever the subjects within the society, it should be regulated by the law. Then we know that we call territorial limitation of a state means that's a national borders. Within the national borders of territory, land territory, or water, we call territorial waters, and our territorial airspace. So these are the three types of territory. We make our law, we apply our law, we enforce our law, and if there is disputes and problems are coming, we apply justice before our system of courts. That's called adjudicatory framework. So this is what we call national law. Why we talk about national law? To understand international law, you should know the key features of national law. Key features of. Can you follow me? Am I audible? Hello. You're
Another,
following me?
yeah, I'm following. We are following, sir. Another thing is, I need to tell that if let's say the call ends, I will put another link. Okay, I will
Okay.
put another link. Everyone know the link, right? ARW. Yeah, you know, right? ARW. The second link that always I put on the second
Okay.
class, ARW. So kindly join in that ARW. So I'll send the link to everyone.
Okay.
Oh, wait.
So, Mr. Ram, we want to rejoin for that.
Sir, maybe you just talk about it and we will rejoin if the link, when the link here
Okay.
on, and we will rejoin on that same link. Can, sir. I will put into that seat message here. So everyone
Okay,
here will know that we have the link. We basically everyone knows the link. So I will send the link to you personally.
fine, fine.
Okay, sir.
So then you mean I have to log out and rejoin?
Yeah, log out and rejoin in maybe another 5 minutes time.
Okay, okay. Quickly, I'll wrap up my first portion of my discussion. Why I'm
Mm.
talking about national law? It's because in order to understand international law, we should know the aspects of national law, right? So now we know the national law. Now we can talk about international law, right? What do you mean by international law? There's a definition. We have international law means what? It is what we call set of rules by which the relationship among society, a relationship among states are governed by. So a set of rules by which the relationship among states are governed. So now again we are talking about set of rules, the relationship among states. What do you mean by states? Why do you want to govern states? These are the main features we are going to talk about it, right? Fine. So then I think it's time to switch to the new link.
Better.
Thank you. Thank you. Thank you.
We will rejoin in the second link, everyone. Kindly come into the second link. Okay.
All right, thank you, sir.
Thank you. Thank you. ARW. Okay, welcome back, everyone. Maybe can hear me loud and clear. Okay, good. Got some water sound. We can mute. Okay, sir. We can continue, sir.
Okay, right. Thank you. Thank you, Mr. Ram. So what I started with the definition of international law. So before we go into the definition of international law, law can be divided into three limbs, right? Law can be divided into three limbs. Number one, what we call national law, or what we call domestic law or municipal law. There are three terms, we call it international law. So that was called national law. Second limb, what we call international law. International law can be divided into two limbs, right? Number one, what we call public international law, private international law. The third limb, what we call supranational law. These are the three limbs. The first one, what we call national law or municipal law or domestic law. First one. Second one, international law, that can be divided into public international law, private international law. Third one is supranational law. These are the three different types of law. I already explained to you about the first limb about national law. National law means the law which is applicable within the national territory of a state. So that we have a very clear parliament to make law. Executive arm of the state is there to implement the law and enforcement of law. And we know that state agencies are there, police, customs, and other system of enforcement are there. Then the third one, what we call adjudicatory system, is called judiciary. Supreme Court, Court of Appeal, and other court system is there. So this is what we call a national law. Why we call domestic law is when we consider aspect of the system is called domestic system. So therefore we call it domestic law. The third one, what we call third name, what we call municipal law. So when we call municipal law, also when we discuss about international law, we call a special name municipal law. All these three names are referring to the national law which is applicable within the national territory. Second area, what we call international law. So what is the meaning of international law? International law means a set of rules which is applicable between states and different nationals. So then the same international law can be divided into two limbs, what we call public international law, second private international law. So what do you mean by public international law? Public international law means the a set of rules which regulates the relationship among states. Again, a set of rules which regulates the relationship among states. So then this is what we call definition of public international law. Second, what we call private international law means a set of rules which regulates the relationship between two or more different nationals on their personal transactions. That is called private international law. Right? So this is what we call international law. We will discuss later in detail. Third area, what we call supranational law. Supranational law means what? The law system and everything there, but no territory. What we call European Union law, European system, European Parliament, European human rights system. We know that there are European system is there, African system there, inter-American state system there, ASEAN is a system of governance. So ASEAN having a system now. Likewise, we can see intergovernmental systems are established in order to regulate their relationship and their dealings. When we talk about that their dealings, right? So this is what we call supranational system, supranational law. No territory, no specific people, but system, governance, everything there. That is what we call supranational law. I think now you may understand what do we mean by supranational law, right? Now these are the three main areas. I think you are comfortable with that. Even if you want to ask any questions in between also, you can ask, you can interrupt me, no problem. So then what we can talk about, the first one, national law. Second one we will talk about, there are two limbs we discuss about it. International law, public international law, private international law. So private international law means, for example, right, a Malaysian married to an Indian in the UK, migrated to Canada, and they had a job in Australia and South Africa. So they have multiple countries they were going through. Finally, they decided they don't want to continue the marriage. They want to get divorced. So finally, when we see that the boy was, though he's an American boy, Malaysian boy, he is a citizen of USA. So the girl, though she's a Indian girl, she's Australian and citizen. So then what happened? They registered their marriage in the London under the English law, UK law, but they wanted to get married in Canada. They got married in Johannesburg, and they want to get a divorce. This is what we call complex law, conflict of laws. So how to resolve this? There are different systems of law to resolve the problems among different nationals in their personal transactions, personal relationships, legal relations, right? Apart from that, this personal we call commercial transaction. There are companies exercising and engaging in import, export, and so on. One country is export, another country is in third country involved, and so many other countries are involved. In this also, we have to decide jurisdiction of the which states. That also part of what we call private international law. So this is what we call private international law. It's in other word we call conflict of laws. So this is a very complex area because we don't want to touch upon right now. So our main focus today, international law. When you talk about international law is a set of rules which regulates the relationship among states. Now we can ask, okay, why what are the primary subjects of international law? We say states. States means what? It's a state means there is a definition, organized political entity which has permanent people, defined territory, sovereign government. Therefore, you need international relations. So that is what we call state. Okay. So what is the relationship among states? Yes, because now states can't live alone. So states have more relationship, bilateral relationship, multilateral relationship, and they have global relationship. So therefore they have to engage in more and more other dealings, maybe formal official dealings or bilateral dealings. So then we can say diplomatic relationships. People are moving country to country, so we have to have a diplomatic relations, and so on. There are many more systems are there between states. So then when we have the systems, we know that every state is an independent state, sovereign states. They have political autonomy, political independence. Things are there. So among states, there are some states what we call superpowers. There are some states are developing countries. Some states are industrialized states. Some states have still having monarchy system. Some states have constitutional monarchy. Some are very much traditional countries. So different types of politics or political system there. They have different constitutional governance there, and different cultural background, different what you call economic systems are there, different social systems are there. There are differences. When we see their military power, mighty military power, and also sometimes they are weak. Some state have more resources, some state have limited resources. Some state have ocean resources, some state they don't have ocean, they're landlocked countries. When we talk about states always, they in the past also, they had a problem about their exercising their sovereignty. One state wanted to exercise power, use power, threat of the use of power against another state, and they had wars, a series of wars they had. Then after that, in the Westphalian 14th centuries, they had a Westphalian contract. Finally, they agreed. Sovereignty of states is a fundamental principles of international law. So therefore every state's independence, political autonomy should be respected by another state. No state intervene into their internal affairs. This is what we call system of international governance. So then when we call states are sovereign equals, that's a fundamental concept of international law. When we say states are equal in their sovereignty, one state cannot dictate terms on another state. So, for example, when just imagine in your classroom, when you study in the schools or the college, you have your classrooms. In the classroom, all your batchmates or classmates are all equal. All should be treated equally. So no one is superior, no one is none is inferior to anyone. So therefore all have been equal. But this equality is compromised sometimes. How it's compromised? Now we are friends, we are equals, we have no hierarchy, we have no dominance, we have no superiority and inferiority, but we all are equal. But sometimes when our friends ask some help, when our friends make some request, we listen to them and we follow that. We will comply with their request and demands and requirements, right? When we do that, it is what we call, we compromise our sovereignty, because I'm an equal sovereign body with my peers or my mates, my friends. So then I compromise my sovereignty, because of I have to be with him and with the friends, and we have to be peaceful. So therefore, when there is a problem comes, I have to talk to him and resolve my disputes. This is what we call sovereignty. Sovereignty can be compromised for the purpose of peace and order in the world. This is the purpose of international law. Later stage, then the mighty states invaded small states. Then there were wars and fightings amongst states. The First World War, Second World War were there. End of the Second World War, they decided, okay, fine, hereinafter, we don't want to have another war. So therefore, they established the peace-loving 50 states set together in San Francisco in 1945. They established the global organization called United Nations Organization, UNO, in 1945. What's the purpose? Protection of or maintenance of international peace and security. Why do you want to maintain? Because we lost the peace and security in the past. The First World War, Second World War was a very bitter experience. Now we are going to, hello, can you hear me? Hello? Okay, so we have to ensure we are having, can you hear me? Am I audible?
Can, sir, can hear.
Oh, okay, thank you. There was some different disturbance, that's why.
Okay.
Fine. Now when the United Nations was established, but the primary purpose or a fundamental purpose of the establishment of the United Nations to bring international peace and security, or to maintain international peace and security, to avoid any states creating troubles and all. So therefore, that was the whole purpose of the United Nations. So maintenance of international peace and security means, then we understand there are some troublemakers to international peace and security. For that reason, we need a global organization to maintain peace and order. And also the United Nations, in the objective clause, you can see that the Charter of the United Nations, the Constitution of the United Nations of 1945, very clearly specify the purpose of the United Nations. In the Article 1, in the objectives and everything is clearly defined. Article 2, you can read that there are some objectives of the United Nations. In the objectives, very clearly stated that the international law is going to be maintained by the United Nations as a tool of governance, right? And also, the state sovereignty should be respected. Internal affairs of a state should not be intervened by any other states. No state can intervene into internal affairs of another state. When there is a dispute among states, when there's a problem among states, the state cannot use force to resolve their disputes, right? And also the states always should be peace loving states. If they have a problem, they have to use through their differences and problems to resolve through the peaceful means. These are the fundamental purpose of the United Nations. So this is what we call purpose of the United Nations. The United Nations apply rules of international law. This is how we continue to have this international law. Now subsequently we can see how the international law is coming as a governance system. So for that purpose, what we can say is international law is a set of rules which governs a relationship among states. Now we are asking why we have to govern the relationship. Governance means you can't have the governance system like what we are having within the national system. Within the national legal system, we have sovereign parliament to make laws. So when parliament make laws, we have to comply with. We have to follow. We abide by the law. We have to respect the law. If we violate the law, we are subject to the legal proceedings. We have to respect the law. But in international law, the law set of rules are there which cannot be seen the same way. Why? Because there is no global law-making body like parliament in a country. Why? The particular system, how it is functioning, it's called the governance based on consent. What do you call consent-based governance? You can't compel or you can't bring any compulsory rules of governance. It is only consent based governance, that is what we call international system. So therefore governance, there is no supreme body of parliament, there is no supreme body of executive or enforcement system, there is no supreme power of adjudication system, there is no specific parliament or what we call parliament, sorry, supreme court or any other system, right? So this is what we call international system. Now further we can see how we can call international law as law. Now because technically speaking, law means a set of rules which is created by the sovereign holders. That means parliament should make law, otherwise who with the entity or a person who is having sovereignty should make the law. But by what we call international law is also we call law. So that's the reason we are asking whether international law is really a law or not. We can't call international law technically as law. Why? There is no law-making body. It is consent based governance. Therefore international laws are moral, what you call moral or positive morals, not positivist law, right? So therefore what we can say is these are ethics we have to follow in our international system. That's a reason what we call. So the international law, how rules are originate, how international laws are created. International law is created through state practice. That's a primary function of international law, to ensure state practice are smooth, peaceful, friendly, and compromised. So when we see state practices, one state do some action or engage in an omission that is repeated, another state is tolerated, that is becoming practice. So when one state do something, another state welcoming the same action, that is accepted, recognized, that becoming state practice. So this is how the state practice are formulating. So later stage, when they formulate the state practices are accepted and recognized by other states, then that's becoming crystallized practices of states. The crystallized practices of states becoming inviolable rules. So states feel, psychologically states feel they are comply with, they should not violate, they should not go beyond these practices. That is what we call customary rules of international law. Why? By practice, by customary system, we recognized, we accepted, we are complied with such practices. When did you start? Long time. Likewise, the what is called customary rules, customary practices. This is what we call customary law. Why? States respect those rules as customary rules. This is what we call mainly sources of international law, right? So then we identify in their relationship, they engage in their relationship, they exercise what you call they engage in number of what you call negotiations, their discussions. The states are engaging in their negotiations, discussions. Finally what they do, they come to a conclusion and put their understanding in written form. The written form is signed by both states representatives, so they are leaders or political representatives. Then that is what we call an understanding in written form or agreement, or otherwise what we call treaty Treaty, treaty is an agreement. So then this is what we call states compromising their sovereignty and accept the obligations. When a state when a state sign sorry, hello, can you hear me?
Exactly. Yeah, can hear.
Sorry for some interruptions, right?
Okay.
So when states sign their sign agreements or treaties, what we call it is called international treaties. Then states have 6 types of obligations. First one, respect your obligations under the treaty. Number 2, protect your obligation without violating that obligations. Number 3, ensure your obligation. Ensure respect. Why? You as a state, you have to respect. Number 2, your subjects. Ensure your subjects all are also respecting the obligations. Third one, protect from any violation. Promote advancement of that particular standard agreed. Right? Then in the event if there is any violations, remedy for the victims and aggrieved party. Finally, if there is any compliance system in the agreement, in the treaty, you have to address and fulfill those obligations. These are the 6 types of obligations are there under the treaty. This is what we call treaty obligations. Right? Now we can understand, if someone is coming and asking, so where we can find international law, we can say primarily 2 sources: customary practices of states, and also we can say treaty laws. These are the 2 primary sources. There are some other sources, so because in considering time I cut short that. But when Mr. Ram at the initial stage, he asked the question hierarchy of the sources. When we talk about hierarchy of sources, I will start like this. When within the national court, let's presume before the Supreme Court of Malaysia, parties are filing cases and bring the case by one party against another party. Judges are there to adjudicate the case. So generally what they will do, according to common law system or civil law system of the system, what we say is, generally we ask, is there any parliamentary laws to resolve this problem? Then both parties submit their parliamentary laws and a court will interpret and resolve. Right? That's a role of the courts. Parliament can't resolve every problems, no. Parliament will make framework law. The framework law will be reinterpreted by the courts, judges. Judges will interpret. So the black letter laws will be given life and light by the judges' interpretation. When judges interpret that provisions, we can apply to the problems. So then, if there is no solution in the statutory or parliamentary laws, then we have to look for another sources. That is what we call source. So then judge will look into any case laws are there. Then the judge will see, is there any customary practice? Then judge will see, is there any opinion of juries there? If there is no anything, he will go to his natural justice principles. This is what generally we follow the system, right? There is a slight difference between civil law country sources of law and common law country sources of law in the level of hierarchy, right? This is what we call hierarchy of sources. But generally in the common law system in the UK, the primary source of law is the case law, judicial precedent. So if the case is coming before the judge, judge will see is there any decided cases. Then he will decide according to that. In Indian Sri Lankan legal system, what we see is predominantly is there a statutory law, is there a parliamentary law. If there's a parliamentary law, we apply. Otherwise, only we will look into the judges previously decided cases. It's called case law. Then we can go to the customary principles like that. You can see now within the national system there is a hierarchy, but in international legal system, very difficult to establish a hierarchy. Why? The system functioning based on state consent-based governance. So therefore, it is very difficult to establish a hierarchy. If you establish a hierarchy without assessing the one particular source, you can't quote another source. But for example, in the national system, if you want to apply case law, you have to fulfill the requirement of legislation. You have to ensure no solution in the legislation. Therefore, I am consulting case law. If you have solution in the law, parliamentary law, then you no need to go to the case law. You can interpret. If there is no solution in the parliamentary law, no solution in the case law, then you have to go to customary practice. If there is no customary practice, you have to go to the opinion of jurist, legal writings. There is no solution in that also, then you have to go to the natural justice principle, and judges can decide according to their own conscience, right? Like that, there are many steps are there. This is what we call sources of hierarchy of sources. But in international law, when we ask what are the sources, we are referring one particular provision in the statute of ICJ, right? Statute of ICJ. Don't forget, Mr. Ram emphasize on that. What we call Article 38(1) of the Statute of ICJ. What in by Statute of ICJ? The United Nations Constitution, that United Nations Charter of 1945, is the Constitution of the United Nations. Along with statute, annexure, along with document is there, what we call Statute of ICJ. That means the system and structure is defined by that ICJ statute. When you talk about Statute of ICJ, when you sign United Nations Charter, you are indirectly accepting the ICJ statute also. But if you are going to be governed by the rulings of the ICJ, you have to make a special declaration. That's a different issue. In the ICJ statute means the ICJ is one of the organs of the United Nations. That means a principal judicial organ, right? We know that General Assembly, Security Council, Economic Social Council, the Trusteeship Council, the Secretariat, and ICJ. ICJ is a judicial forum of the United Nations. When you say the United Nations, when the cases, when members, when they have problem, international disputes, they can bring the cases before the ICJ for adjudication. So ICJ has two types of jurisdiction. Number one, advisory jurisdiction, and also contentious jurisdiction. Advisory jurisdiction can be invoked only by the United Nations and their members or organizations or special agencies. On the other hand, what we call contentious cases, that mean argumentative cases, can be brought only by states. So recently we know that the South Africa versus Israel case, the case was filed by South Africa based on a genocide conventional violation principle. So against Israel. So only states can bring the file. But in international criminal court, individuals can file a case against another individual if they are party to the ICJ statute. That's a different issue. So now this is what we call source of international law. But in international law, it is very difficult to maintain hierarchy. If you maintain hierarchy, its adjudication and the consent-based governance will be very difficult. Why? Sometimes you can make new conventions, you can have established new customary practice, new state practice can be there. Sometimes you can bring new statute in contravention of your customary practice. Sometimes you can have established a new customary practice beyond your treaty obligations. Therefore, there is a difference. But there's another principle called jus cogens. Jus cogens are fundamental norms of international law that cannot be violated. Even in violation of jus cogens, you cannot engage in, you can execute any treaty also. That's a different issue. But general aspects, general practices can be made by the states. What we call statute, so what we call the treaties and customary practice, there is no specific hierarchy. So what gives the best solution, valid solution, reasonable solution can be applied. That's an interesting part of the international law, right? So that is what we call international law, right? The role of international law mainly for academic purpose, what we call sources of international law, and what we call personality, international legal personality in international law. What do you mean international legal personality? Whether you are having any rights, obligation, duties, and any liabilities under international law, then you are subject of international law. Earlier we know that we were talking about definition of international law. Only the states are the primary subjects. Then we add when we add states, intergovernmental organizations, multinational corporations, and individuals also becoming part of international law because they acquired minimum personality in international law. Why? They got some rights, duties, obligations in international law. So that's the reason we call them also part of international law, right? That's part one. Part two, we can say that, so when you are having international law, you are becoming a subject of international law, you have to fulfill your obligation towards that. You have to respect international law. States respect international law. Why? You enjoy rights, you enjoy benefits from international law, therefore in return you have to respect. So that's the functions of, and likewise international intergovernmental organization, the United Nations intergovernmental organization, ASEAN intergovernmental organization, European Union international organization, Council of Europe international organization, or intergovernmental organizations. They have obligation towards other states and international law. Likewise multinational corporations and individuals also there. Individuals also becoming part of international law because after Second World War, they established Nuremberg Tribunal and Tokyo Tribunal. Individuals were punished because they violated fundamental principles of international law, because they were punished according to the principles of international law. So therefore, they also become subject of international law. Now we call about human rights. Human rights are, we got the human rights recognition. Human rights are natural, but we got the recognition through international law. So we feel that international protection is there for us to enjoy international law. So therefore, international law protect our human rights. So therefore, individuals also we are having human rights. So therefore, subjects of international law means who are having some rights, some duties, liabilities and responsibility under international law. We call them as they are subjects of international law. Fine. Right. Now we can talk about the recognition in international law, state recognition and government recognition. What do we mean by recognition? Recognition means when a political organization becoming a state. So you have to recognize a state. No? If it's a state, what are the salient features? For this purpose, there is no specific convention, but we found one reference called Montevideo Convention of 1933. Article 1 says on the duties and rights and duties of states. It has 4 features. Number 1, you should have a permanent defined territory, permanent population, sovereign government, international law. Sorry, you are becoming a state, what you call statehood, right? Statehood. In order to achieve statehood, you have to fulfill all these four. This is what we call four main features. Then again, we can talk about what we call. There are two principles associated with the recognition of states. What you call constitutive principle, declaratory principles. When you say constitutive principle, if you have all these four elements only, you can become a state. You need recognition. Recognition is must. Right? When you have a permanent population, defined territory, sovereign government, and what you call the international capacity to engage in international relations, you can become a state, but you need recognition. You need recognition. Without recognition, no states. So the new state, for example, South Sudan, Kosovo, now we are talking about be recognized, and all these what we call new issues, right? New situations, right? Fine. So this is what we call new steps, right? Fine. Okay. So now another area, another aspect, what we call de facto recognition, de jure recognition. De facto recognition means when these days states are recognizing Palestine as a state. Yes, that's politically we can recognize. Legally we can recognize. So de facto recognition means it's a temporary recognition. De jure recognition means permanent recognition. When we call permanent recognition, we exchange military, diplomatic engagement. We open our embassy there in that country. They engage in this country, and if they start a diplomatic relations, it's called de jure recognition. So therefore, this is what we call state and recognition, government recognition. When you have a state, you should have a sovereign government. Sometimes we have recognized the state, but the problem of recognizing the government. Afghanistan, for example, Afghanistan is a state, sovereign state, no problem about recognition. But the problem there, recognition of government. What we call recognition of government, we have to think about recognition of government. We call sovereign government means whether you control your people, whether you control your territory, whether you have national defense, whether you have you are recognized, your government government is elected by legitimate means, that's mean democratic way, then only other state recognize the government, right? So these are the aspects we have. We can go for the case studies, but we don't have time. This is what we call recognition. Then we can talk about state jurisdiction, right? What we call state jurisdiction. When we call state jurisdiction, the state has three types of jurisdiction. Number one, to make law, to enforce the law, right? To prescribe law, to enforce law, to adjudicate law. There are three areas. They can make laws, right? Any state can make law within the territory of their state. They can exercise, no problem. Enforcement is very difficult to enforce. Only they can enforce the law within the territory. Adjudication also within the territory, no beyond the territorial limits. The persons, properties or assets and incidents taking place within the territory, we apply national jurisdiction. There are 5 principles are there for national jurisdiction. We call territorial principles, nationality principles, passive personality principles, protective principles, and universality principles. There are 5 principles are there we apply. So this is what we call jurisdiction. Beyond the jurisdiction, we have exemption or exceptions for this jurisdiction. What you call state immunities, diplomatic immunities are there. State immunities are given for the state and for the states and the head of the state and foreign minister. But diplomatic immunities are given by given for the diplomatic relationship, right? So this is what we call state immunity and diplomatic immunity. What do you mean by state immunity, diplomatic immunities? They have immune from civil and criminal liabilities from the national courts. So I'm a Sri Lankan, I'm in Malaysia. If I'm a diplomat, Malaysian laws are not applicable to me because I'm exempted, because I'm Sri Lankan sovereign. So like that, this is what we call immunities, right? Okay, fine. I think we may have to join for the new link. Mr. Ram, is that correct?
We can continue up to 10:10, but if you want to have break, you want to have a bit of 5 minutes break and come back.
No, I think we can continue. No problem.
Continue.
So
Okay.
till what time the same link can be used?
10:10.
Okay, fine. Now before that I can finish. No problem.
Okay.
I'm sorry for it's maybe I'm maybe going very lengthy and extensive, but I'll cut short my session. Fine. So then what we call another specific topics in international law, we call it state responsibility. What do you mean state responsibility? State responsibility, what we call the state responsibility for internationally wrongful acts. There are international wrongful acts are there. When a state accepts some international obligation, we have to respect. We have to comply with that. If you fail to comply with that, we are answerable. We have to pay compensation. That's for the state obligation. So this is what we call in 2001 there is a particular resolution, general resolution there. What are the acts are attributable to the state for their what are the specific acts are specific what we call actions are there attributable to the states and not, right? This is what we call state responsibility. For example, I'm a Sri Lankan, I have come to Malaysia. So when I'm come to Malaysia, I should be given as a I have visa holder, valid visa holder. So I should be given protection because tourist destinations are there. When I go there, I should have be given adequate protection. If my rights are violated, it is a obligation of the state to get me compensation. Why? Because if state agents harm my rights or violate my rights, state is liable to pay me compensation. Not individuals, state. It's called state responsibility for international wrongful act. Right? Fine. Then another area what we call final, this is the last topic, use of force. In international law, you cannot use force to resolve your disputes. You have to resolve your problem peaceful means. So therefore, using force is prohibited except for the purpose of self-defense or collective self-defense. You can use force. So what do you mean by self-defense? Because your rights are going to be violated as a state, then you can use force. Collective self-defense can be used under Article 42 of the Chapter 7 of the United Nations Charter. The Security Council can pass a resolution to use force against another state because it is a violation of that particular situation. The situation is going to endanger international peace and security. For that purpose can be used. So this is what we call international law of use of force. Then finally, last session, what we call peaceful disputes. What we call peaceful settlement disputes. When there is a dispute between states, those disputes can be resolved by peaceful means. What do you mean by peaceful means? Because there are two types of peaceful means. Number one, diplomatic means. On the other hand, what we call legal means or judicial means. Diplomatic means we will have a negotiation, we'll engage in conciliation process, mediation process, and then we appoint a good office to resolve the dispute and so on. We are having different types of approaches. It's called diplomatic approach to resolve a dispute. If we could not resolve diplomatically, we will apply what we call legal means or judicial means. When we go to International Court of Justice or any other tribunals or arbitration to resolve our disputes. So then when we talk about International Court of Justice, that's the main topic. ICJ. ICJ is a judicial organ of the United Nations, which has two specific powers, mandates, specific jurisdictions, advisory jurisdiction and contentious jurisdiction. The judiciary can resolve, ICJ can resolve the international disputes according to international law. That is the purpose we talk about ICJ statute. Fine. So these are the academic topics of the international law. Now we can see quickly implementation and enforcement, role of international law. Now you can see since 1945 whether international law were able to achieve universal or international peace and security or not. It's a failure or achievement. When we see, there are both sides. There are many achievements, there are many failures, but the system itself, the United Nations Security Council system, is seen after this Palestine issue. We see it's a failure of the United Nations Security Council system, because when the people's rights are violated, the United Nations fail to address the issue. Because what's the purpose of the United Nations? To achieve or maintain international peace and security, protect rights and freedoms of individuals, and ensure self-determination of people. These are the three purposes: maintenance of international peace and security, protection of rights and freedoms of individuals, and ensure a right to self-determination of people. People mean group, nation, a country. So these are three purposes. Whether the United Nations achieve these three purposes or fail to achieve these three purposes. So we know that since the establishment of the United Nations, we have seen Yugoslavia, Bosnia, when Rwanda, and Myanmar, and Vietnam, and Cold War, and Cambodia, Laos. There are many violations, many laws. Now currently in the Palestine territory, humanitarian catastrophes are there. So we can see the international system failed to address these common problems. So, but we wanted to achieve this. At the same time, we can see establishment of tribunal, Nuremberg Tribunal, Tokyo Tribunal, for Yugoslavian Tribunal, Rwanda Tribunal, Sierra Leone Tribunal, Cambodian Tribunal. Then subsequently, from 1998, Rome Statute International Criminal Court was established. So therefore, we can see there's achievement also. Then people respect the United Nations also. But the problem is the superpower state, superpowers, and the United Nations system, what you call Security Council system, is it's making international peace or breaking international peace. That's a point of our discussion today. Okay, that's all. So then we'll have a quick 2-3 minutes break and we'll join again to the new link. Thank you, Mr. Ram.
Everyone, I will put the link in the group, but meantime, kindly look into the link here. I also will put it to the link in the group, our groups lah. So we'll join in the third link on the importance of why we need international law. Okay, kita jumpa dalam link ketiga. NMB. Okay.
Okay. Hello, Mr. Ram. I'm available. Is it time for the questions and answers? I think I was too fast to talk to you all. I'm sorry because of constraints of some time. I was too fast actually. And but this is the time for any question and questions. I will try my level best to give you a brief answer to your questions. Please, it's open.
Yes, sir. For a while, sir, we wait for more people to come in just now, right? So, anyways, it's actually very fruitful, and also we understood because international law is a very wide subject, right? True or not? So we need a lot of time to address all the issues. So that's why I was thinking about maybe we'll have a few more sessions, few more classes, and we would like to bring you in as our guest lecturer, or we call it as a person that we respect, and so we want your knowledge to be given or shared to us also. So it can be done in future. We hope that you also will join us as a team.
Thank you. Thank you. Thank you. Thank you, Mr. Ram. It's a Google team, no? Right. Yes.
Yeah, so we always call this as a law with Ram, as a group of law with Ram, but mainly we are the UM students lah. So mainly we are studying and learning at UM, and we are taking up bachelor degrees and all that. So it's very fruitful just now. Very good subject, and I also learned a lot of things, a lot of issues. What you said, and maybe we can open for questions now. Anyone have any questions? I say, is this topic self-determination linked with territory? The first question, sir.
Yeah. Can I respond to that, Mr. Ram?
Can, sir.
Yes, it's a contemporary discourse, self-determination and territory. Yes, right. No, because what do you mean by self-determination of people? So generally, whenever we call the word self-determination, we call always people. The self-determination aspect of became international norm or international law. It's because a group of people or a particular people, their right have been violated in general by many powers. So therefore their political identity, ethnic identity, religious identity, or other any characteristic of their social standing should be recognized and respected. So when their rights are violated based on religion, based on culture, language, skin color, or otherwise, then the aspect of self-determination started. So during during the United Nations formation, the main topic was the people's right to self-determination was main subject. Why? During 1940s, there were many states were struggling to get their independence from colonial domination, and people were struggling and they were fighting for freedom, right? So then, and also during that time, the Jewish people encountered a severe genocide, Holocaust. So therefore, in order to give self-determination to people, whatever the religion, whatever the background, for that purpose only, they started to talk about a right to recognition of the particular people's political independence to be recognized as a nation. So therefore, from that point onwards started self-determination. When you talk about self-determination, you have to have certain attributes to claim self-determination. Attributes means what? So earlier we were talking about, if you wanted to be known as a particular nation, particular group of people, particular nation you are going to be, you have to have a distinct culture, distinct religion, and you have a prescribed territory to formulate and organize your culture, practice, religion, and so on. And you have a root cause of practices and life. When you have all these, you are going to be recognized as what we call self-determination of people. Self-determination is starting as a right, fight for rights. Then in the course of recognition of self-determination, people are becoming a nation, then they are recognized as state. That's a point of start. So therefore, when you recognize a people without a territory, without a domestical, without a territory or without the place to live for them in order to ensure their identity and culture and other practices, you can't have a nation. So therefore, the territory is very important to be recognized for the purpose of self-determination. States, they have claimed, they have their self-determination with the recognition and with the establishment of territory. Without territory, it is very difficult to ensure the identity, unique identity for a nation for the purpose of self-determination. So there are many examples, but I have given you a very succinct, very summarized answer. I think that would be fine, no? Yes, Ami, you got the answer.
Yeah, because that also include in ASEAN, right, whereby we can see that Timor-Leste also been part of the self-determination when they asked themselves to be freed from Indonesia, and they also went through the referendum of United Nations and become self-determination nations now. Am I correct, Mr. Okay?
Yes, that's correct.
So how are we going to link this towards to the Palestine? Can we say that Palestine went through the same self-determination?
Yeah, Palestine now, rather than what we call self-determination, we can argue on recognition. So when you call self-determination, for example, I think I can quote about Sri Lankan case and then Palestine case. There are two issues. In Sri Lankan case, when you talk about Sri Lankan Tamils, they fought for, Sri Lankan Tamil fought for separate state. That means Tamil Elam for the purpose of self-determination, because Sinhalese, they decided the political survival of the Tamil people. They said, no, let us decide, let be organized as a nation, and we need a self-determination, separate state. Because established states there, within the state, they want to establish another state because of self-determination, recognition, separation, likewise. But when we talk about Palestine issue, rather different, because Palestine issue from the origin, Palestine has been a state. Recognized state.
Yes.
It has more people. There were Muslims and Christians, Jews, and they more religion. It's called Abrahamic religion was the foundation of Palestine and other areas in the Middle East. Because the question is whether Palestinians ask for a self-determination means they had no previously their own state. Now they are looking for a new one. No. For my personal opinion, they are asking for recognition of their state, Palestinian state. Now the problem is state recognition. I think we can see the recent Security Council resolution with regard to the recognition of the state. They're talking about the people fight for their state, right? Now the argument is coming, should be their people's right to be recognized as a state.
Yes.
Right? And also when they have an invasion or what we call occupation by Israeli forces, then they call self-determination, because why call? Don't decide our matters by your power, let us decide on our own. That's called self-determination. So therefore recognition, self-determination, both are connected, intervened in the Palestine affairs.
Great, good answer. And therefore, we also condemn the state act of the state Israel, who actually also not following. Can we say that to them? They are not following the exact international law.
Yes, of course, of course. There are thousands and hundreds of rules and regulations have been violated so far. So we have a long list of violations because uh, when we say the peace-loving states, first you have to respect the rights of your people and other people, and you should not violate political independence of other people, other nations, and you should not intervene. And also you should not use force against civilians. You can use force against your enemy, but you should not use force against any civilians. But what we see, what's happening in Gaza and Palestine territories, because it's a real occupation and aggression. What you call crime of aggression is one of the international crimes. It is a serious crime in international law. So therefore, these are the crimes what we can list out committed against Palestinian people. So Palestinians have very clear right to be recognized as a state. They have the right to self-determination, and these rights are being violated by the state of Israel, because Israel became a state is because of recognition. Immediately after it has become it is declared itself as a state, the United States and their allies immediately within an hour they are recognized.
US.
But yes, but other Arab states they opposed. There are many states so far they have not recognized. I think Malaysia also so far not recognized Israel as a state.
Yeah, we can't actually enter to Israel via our passport.
Okay, fine. Okay, Mr. Ram.
So that's entire things summarize as what is the importance of role of international law,
Yes.
of international law, and particularly what you have stated to us related to international law and started from the chapter 1 itself. For me, I will feel that sources and all that connected to all other chapters until the we go for the peaceful settlement and all that, and we also have International Court of Justice. So it's fruitful and very, very important subject to be learned by everyone. And so we are very thankful for your time. And I hope everyone here also, will also continually will look into or explore the international law in future. And this is what I'm trying to say. And thank you for your time. Do you have anything to conclude, sir? Do you like to say a few words to our students, how you going to inspire them for their international law, how you want to tell them the international law is a very good subject and vital for them to know?
Yes, this last few words, Mr. Ram. Thank you for this opportunity, because I'm very happy to share my knowledge, because it's my personal trouble, and with a hectic, I just shared few things with you only, and also as students who are pursuing legal studies, you should know the international law background perspectives. If you know international law, you know the world. You can watch international news. You can understand international affairs. You can talk about international matters. If you don't know international law, you are blind, you are deaf, you are dumb, you can't talk about any international matters. If you know the international law, anywhere, anything happen, you can comment on that, you can criticize, you can tell what is right, what is wrong with your background knowledge. So therefore, international law, without international law, no world affairs, no internal affairs also. Many more internal affairs are being regulated by national international law. I will share a document, Mr. Ram. American Society of International Law, they have prepared how our daily life is shaped by international law. There are 100 ways. So I will share the document. You can share with our friends. They can read, actually understand how daily life, our daily life are regulated by international law principles, right? It's an interesting document. There are 100 ways are there. You can understand. Even if you logged in this Google team, it's international law. When I am talking to you, international law. So each and every aspect, your time and everything regulated by international law. So therefore, without international law, no survival now. So therefore, please learn more and more international principles. You will enjoy. You will understand national system, international system. You will understand people and different cultures and all. So with this note, God bless you all. Thank you so much for the golden opportunity to share something with you all. Good night.
Thank you
God
for
bless.
everyone. Thank you for attending our classes and all that. Thank you. Thank you, Mr. Hakim. Thank you, everyone.
Thank you. Thank you.
Thank you so much. Yeah, I will let him know, and we will possibly I will share all these. Thank you, Ms. Amy. Thank you for the question. Very important. Thank you so much, and thank you for everyone to join. Miss Kate, everyone who join us today. Very, very thank you, Miss Cindy, Miss Sonia, Genji, Lisa, everyone. Thank you so much. Thank you for the great time. Thank you.
Thank you, sir. Good night. Bye bye.
Okay, good night. Bye.
Thank you, sir.
Thank you, sir.
Thank you.
Good night.
Good night. Thank you.